Hi guys, it's Kathy. I hope you're doing well. So today we're doing something a little different, even though we've done it before. There was a trial in Australia. It was about patients who would go to this doctor to get a prosthetic, I think, and they would develop infections when he did the amputation and things like that. So it was a very, very, very long trial. I mean, it took so long. It was years. It was years to get to start to finish. I don't have the whole thing. We're not watching the whole thing for the verdict or the ending. Don't know what it is. But what we're doing today is we're going to watch this lawyer from Australia, Sue Chrysanthu. She's so good. So, what I thought I was going to do after yesterday's stream was I have approximately 20 hours of this trial saved. And I was going to pick out the best parts that I wanted to show you. And we were going to watch that today. But there was absolutely no good way for me to get transcripts of all 20 hours to pick out the best. And my last stream was 22 hours ago. So I didn't, there was no way I could go through all of it and find the best. So we are just going to watch a piece of one. And that's what we're going to watch. And these are all on my Patreon. So I'll put the link to the one that we're watching in chat. And if you want to watch it, you can go there, and you will have my Patreon, and you can see all the rest too. So let's see where we're at. I just moved it to get the link. It's good enough. It's good enough. Here we go.
Made a submission that the earliest possible hearing date was appropriate and consented to the September date that Your Honour offered. So it was not the case that the applicant forced upon the respondents a date that they told Your Honour they would never be able to meet. At that time, in February, Ms Barnett foreshadowed that they were already...
I suppose in fairness, you had asked for as early a date as possible, and I said in light of the circumstances,
yes,
we could give that.
But it wasn't opposed. There was no
I understand
dispute.
that, but it wasn't, yes, it was in particular circumstances.
Yes, Your Honour, but also in circumstances where the defamation practice note foreshadows that parties should be ready to take a date in these sorts of matters, even at the first case management. Now, Ms Barnett was aware of and informed Your Honour and us that an amended defence was being prepared, so that was underway. And a consent timetable was entered into in relation to this exchange of evidence. And the day of the, days before or the day of the evidence being due, Your Honour and we were told that no evidence would be served. So 8 weeks passed, nothing was served. And that resulted in all of the evidence being served on us in a very short time frame leading up to the trial. And Your Honour will recall, I informed Your Honour that in order to accommodate the trial date, I'd changed juniors. I'd gotten rid of 2 excellent juniors and replaced them with 2 other juniors because of the timetable.
I'm assuming you regard them
all
as
excellent.
as
all
well,
excellent.
otherwise,
I've never seen a bad junior, either on my learned friend side or on our side.
We're all used to dealing with hospital hand passes.
Yes. Now, the change in the timetable particularly caused me and my juniors a problem because we were all in another case in July. And I told Your Honour that. I told you that it was going to be a difficulty. Now, it was because of the respondent's failure to comply with the timetable, and Your Honour has seen this correspondence in the past, and it's in the procedural chronology we've handed up before, that when we consented to the amended defence, which was prepared after the respondents had all their lay evidence, we said, we're relying on the defence to answer your claims. You've had the chance to amend after you've put all your lay evidence on.
Is this a pleadings point?
It is, Your Honour, and I'm going to explain it. We've relied on your amended defence. You've had the chance to amend it. We've consented to it. We are preparing evidence, and we have been preparing evidence based on your defence. Now, in Rush, and we've given Your Honour the reference, the reason why, unlike many other types of cases, the particulars of justification in defamation take on significance is because even though the respondents have the onus of proof, the applicant goes first in evidence. The applicant has to anticipate all the evidence that's going to be called and meet it based on the particulars, which we endeavoured to do. Now, what then occurred, and I'm not cavilling with Your Honour's judgments about rulings of evidence, is Your Honour formed the view at trial that if the evidence appeared in the affidavits or the expert reports, irrespective of whether it was pleaded, in some cases, not in all cases, it would be allowed in. And on each...
Otherwise relevant.
Yes, Your Honour. And to that extent, on each occasion, I said, well, we might have to respond to this. This takes us by surprise. Now, the first thing to note also on that question is when we got the expert reports on the 28th of June, in circumstances where my learned juniors and I were in a trial in July, it was 852 pages from 5 experts, and it canvassed a wide range of patients. Some of the allegations were consistent with the pleading, some were new allegations, and some were inconsistent with the pleading. On the 14th of August, 2 weeks before the trial started, a new expert report was served of Dr. Flecknoe-Brown 6 weeks late. Further expert reports were served during the trial. Dr. Stalley, 2 expert reports of Dr. Stalley in September and October, a new expert report of Dr. Ruff a few days before we commenced this year in March. Dr. Papadimitriou was called as a lay witness only. And he, without notice, gave expert evidence, which I objected to. He also, without notice, gave bad reputation evidence, which I objected to, not to be seen anywhere in his outline. And also, in that period, we had the unusual circumstance where we had produced to us scans from patients, Mooney, Gollum and Young, that we'd never seen before, that hadn't been discovered, and that we later found out because of Dr. Ruff's affidavit in November, he had obtained through making his own inquiries. So in relation to those patients, relevant scans that Dr. Ruff apparently relied upon that we'd never seen, and we didn't know until then where they'd come from. Similarly, Dr. Papadimitriou, when I cross-examined him, made promises that he could obtain relevant scans that we hadn't seen. The 3 that I, in fact, asked him to find, he didn't find, the ones from Mona Vale Hospital, but his 2 affidavits that were served in February and March this year found other new scans.
So they're talking about discovery issues in this trial. All right? And they're back... Nope, I didn't mean it that way. They do things in reverse order. So with us, the prosecution files, and then during the trial, the prosecution goes first. And they say, this is what this person did. Although this is a civil trial. So let's go civil. Okay, the landlord files. And the landlord says, this is why I want to break this lease and evict them. And then if the tenant wants to respond and put on a case, then the defendant can. Okay? So the plaintiff goes, defendant goes, and then in Australia, the plaintiff says this happened. The defendant goes first and says, this is why I didn't do it. And then the plaintiff puts on their case. So what happened was they started this trial, and the trial is really good. You should watch something that's on Patreon because it's pretty good. They had extremes for doctors to give their opinion, and the opinions were controversial. The doctors were controversial that they put as expert witnesses in this trial. Well, the plaintiff brought up reports and studies and things like that that they never discovered. And the judge let it in. And then Sue here was like, whoa, we have to respond to this expert material. We didn't even know it was here. We need to get our own experts. But she didn't really have time to do that. She did anyway, because she already had a pocket full of expert doctors ready. So she was fine. Trust me, she was more than fine, more than up to the task. So that's what she's complaining about right now. Get down. Now this judge, I don't know what you call them, judge. I don't think you call them judges, right? What do you call them? I don't know. And she's not a barrister or a lawyer. She's a junior. Is that right? I mean, she refers to herself as junior quite a bit. So I don't understand. Lawyer, counsel, barrister, junior, all, I guess, I mean the same thing. Okay, Bren says she's a judge. So the judge is also more than up to the task to handle this lawyer. So this lawyer is powerful. There's no other words to describe her. She is a powerful lawyer. She does so well. The judge is equal to her. Don't worry, the judge can handle her. It's it's the other side that has issues with her. But that's what she's complaining about right now. She's complaining about discovery issues, which just sounds sort of boring, but it's not.
That we'd never seen. And in the course of putting on evidence of all that new material for Mrs. Mooney, gave expert opinion as to not just the operation, but also the infection and the process that he says should have led my client to.
So when she said me and my juniors, I get it. She wasn't saying she was a junior. She is a barrister. KC barrister? I don't know what that means, but that's fine. She the barrister and her juniors is what she means when she says that. So
do something about that infection. So we had a lay witness not only give expert evidence and bad reputation evidence that surprised us when he turned up, and I note, Your Honour, he was cooperative. He could have put on an affidavit, but he said he was busy, which was unfortunate. He wasn't too busy to put on 2 new affidavits in February and March, full of new evidence about Mrs. Mooney, including expert evidence. Similarly, Dr. Lyons, his lay evidence was such that we weren't even going to cross-examine originally because it seemed to have nothing to do with the pleaded case. And then, based on some cross-examination...
Although by the time you got to cross-examination of Dr. Lyons, you were aware that the pleadings point as such, simply because it wasn't written on a piece of paper. If it was otherwise relevant, I would permit it ordinarily.
There was one issue I understood from the cross-examination of Dr. Armadiris. That's when it first arose. It first arose because of some questions my little friend put, which alerted me to the fact that the case appeared to be going outside the pleading. And that's when I told Your Honour, well, we're going to have to now cross-examine Dr. Lyons about this. But more significantly, out of nowhere was without notice, right a week before the trial started this year, reliance on this spreadsheet, where no reliance had been placed on this spreadsheet before.
The Rosa spreadsheet.
Yes.
Well, I don't think there's any objection taken to the evidence in relation to the spreadsheet.
Yes, Your Honour, but it's what follows and the opinions expressed connected to that spreadsheet that we're answering.
Well, that you're going to have to address me on.
Yes.
I know the history of the matter. I'm more interested in these particular affidavits and what you say about them and what parts, etc.
Yes, but when my friend says we have notice because of something in an affidavit, that does not capture the issue in circumstances where, going first, we sought to meet the pleaded case. And
you are going to have to, as I said, I'm more interested in the affidavits because there was cross-examination of your client about various matters. And I don't know about these ones in particular. I'm talking generally now from my memory of the proceedings, which would have put, whether you were on notice before the hearing started, you were on notice, you might be said to be on notice before the applicant's case closed and well before the applicant's case closed.
Yes, Your Honour, but that would then require us, while we're sitting in a 6-week trial, to source evidence which was not part of the pleaded case. And if it's a timing issue alone, it's only a timing issue... Well,
for some of these matters, you called expert witnesses.
Yes.
So it's not sourcing elsewhere, it's you had witnesses.
But the onus is on my friend. Why shouldn't we be allowed to reply? Like any reply case.
Because one ordered reply affidavits to be filed at a certain time, and ordinarily one allows reply if it comes from something that has arisen from the respondent's case, which wasn't reasonably foreseeable.
Yes, Your Honour, but the difficulty we have is the ship sailed about what need to be served when. That was in June and July. We become aware of some of these issues in September, October, and then again in March. There's no situation in which we can comply with the orders Your Honour's made.
September, October. The hearing was August, September, wasn't it?
I think it was September, October. Did it? Started on the 4th of September was the first day.
Was it?
Yes.
Yes.
I know, because
going for a
Sue
long
knows
time.
the
I know, because the
exact
week
day.
before I was having a big argument in front of Justice Lee. I remember, because it was on the 30th and the 31st of August I was in front of Justice Lee. That's right, is it? 4th of September. There were some case management hearings, but the trial itself started.
This is happening in June of 2024. So they're talking about 2023, where all this happened.
On the 4th of September. And so by the time we get to the trial and we're being served with new expert reports or late expert reports 2 weeks before, or we're being notified of evidence through the cross-examination of my client, the orders for evidence are gone.
But I'm more concerned about the particular paragraphs or the particular affidavits here. To take an example of what I'd like to be addressed is in respect to Ms Mooney, the report that you now seek to use includes asking specifically about Dr Ruff's answers to questions 1 and 2 in his expert report in circumstances where you led expert evidence in respect to Ms Mooney.
Yes, but we now know from Dr Ruff's evidence that he relied on scans and other items that we did not have. So Dr Ruff's evidence has come in based on a series of items that we were not given or shown until my client was cross-examined, and which were not verified or as evidence until Dr Ruff put on his affidavit in November. So we are...
Dr Ruff's affidavit was when?
In November, after the first transcript finished. And Your Honour ordered that he put on an affidavit. It came much later than the order, but it did come before the end of term. So we we made a decision based on the pleading and what Dr Ruff had said to not respond to those paragraphs. We now have been given Dr Papadimitriou's evidence, new scans and investigations that we didn't know Dr Ruff had relied upon. And we now seek to answer that. I mean, that's the difficulty, to try and distinguish the different questions in Dr. Qarashi's report, because we could have answered them before, is beside the point. We are only answering them now because of this new material.
Well, that might depend on what the content of the... you might have made a decision now because of the new material, but if the answers could well have been, didn't relate to the new material, for example, Dr. Ruff's report that you already had, and you'd made a decision not to respond, well, that's a forensic decision, which may or may not be a sound one. I don't know. I haven't made a decision.
But all of the questions about what happened in that first operation are completely now coloured by the interoperative images that Dr. Papadimitriou and Dr. Ruff now supplied to us.
Yes, but they were after, were they not?
No, they're intraoperative images.
No, sorry. After Dr. Ruff's first report.
No, he says he relied on them. He refers to them in there, and we didn't know what they were. And then we've subsequently found out, because of his affidavit and Dr. Papadimitriou's affidavit, that he asked Dr. Papadimitriou to access them for him, and he looked at them. Now, they weren't annexed to his report. We didn't have them. And clearly, his reliance on those, and there was some cross-examination about it, and my friend tendered them in re-examination, clearly that affects our decision as to his opinions expressed in answer to questions 1 and 2. Because and in his report he says he had, I think, 32 of them, 37, but then he clarifies that and corrects it in his affidavit and says he has fewer.
Report dated what?
The original report from 28 June. Tab 104. Now, it's page 6. So,
26.
Sorry, page 26 of the court book. So it's beside the point that we could have answered it. The fact is we didn't, because we didn't consider it needed answering. But now that he says he relies on all this new material and we all have the material, we do.
Well, if it's in the first report, then you were aware of it. You might not have had it, but you were aware of it.
We actually, I should say, as I said, didn't understand a lot of what Dr. Ruff was talking about, and given it wasn't pleaded, just addressed the pleading at that point. And we didn't understand what he was talking about until this issue arose, where it was explained to us what he was talking about and how he got it. He wasn't instructed with those images, they weren't referred, they weren't annexed to his report, and it wasn't part of the pleaded case.
I understand that not part of the pleaded case, and I understand your submission about the orders that were made, but the applicant's case did go for 6 weeks.
Yes. But we don't comprehend why, when evidence is admitted outside the pleading, the applicant isn't entitled to reply to it. We don't understand if it's a...
But on that basis, you could have ignored the orders altogether and called it in reply, all the expert evidence.
Yes, you could have. We could have.
But that's not the way this trial was being conducted.
Yes,
because
but
I made orders for reply in respect to the evidence.
We could have called all our truth evidence in reply, had we wished. But that would have required Dr. Armendariz coming twice, and that's not usually the orderly way of things.
In this, the manner in which this trial was
Yes.
being run, that wasn't the approach that was to be taken.
Yes. What we did, for a matter of convenience, even though it was reply evidence. So under the sequence, Your Honour, it is all reply evidence. All of our expert reports and all of the affidavits on truth is technically reply evidence. But so that it's convenient, from a case management perspective, it's called first. We're still entitled to have a case in reply if something arises during trial that we didn't anticipate from the pleading and is admitted. Now, we don't comprehend how, given we were literally getting expert reports up until the week of the trial, the second trance of the trial, my friends can properly complain about lateness. They don't say to Your Honour, we're unable to meet this, we're unable to understand it. They don't say any of that. And...
You mean in these submissions?
Yes.
They do say, in respect to a couple at least, they would call evidence, they would seek to call further evidence.
Yes, we don't know precisely what, and it may well depend on the cross-examination. Now, pardon? Yeah, that means they do anticipate that they can meet it. But I'll take the evidence separately.
Yes, you'll need to. But, your client spoke about the operations of each of these people, like Miss Mooney, and
Yes.
said it was, these are my words, not his, that it went fine, there was nothing wrong, etc., etc. And he answered a whole number of things that are referred to now in the reports, did he not?
I think he primarily answered the pleading, not the reports, unless we thought the reports fell within the pleading. He didn't say anything about Mrs. Golan at all because there was no consent, so he was only cross-examined about that. He had no evidence in chief on that. And in relation to the others, he addressed the aspects that were pleaded.
Is it relevant that you're calling different witnesses as opposed to the experts that have already opined on these patients and they're not being recalled with this what you say is the additional information, and does that affect their opinions, and if so, how and whatever?
I don't think so, Your Honour, because the opinions that have been the subject of cross-examination already stand and fall on the material that those experts had. It may well be that their opinions aren't as valid anymore now that we have new material. In relation to Mrs. Mooney, Dr. Tedworth's, Dr. Stoiter was fully cross-examined about the Rosa, sorry, that's not Mrs. Mooney, Mrs. Heffernan. I think the evidence from Dr. Tedworth about Mrs. Mooney and Ms. Golan was very limited, and he was definitely cross-examined at length about Mrs. Golan. Now, in relation to good reputation evidence, we don't rely on a presumption. That's not the point of our reply. The point of our reply is that we had no notice of a bad reputation case. No evidence was served. None of our reputation witnesses were sought to be cross-examined. It's not about whether there's a presumption or not. We still maintain that bad reputation is something that reduces damages and needs to be particularised. But in any event, pleading or not, we had no notice of it. The first time we knew of it is when it came out of my friend's mouth when he asked the question. And so
You have led a large number of witnesses already on this topic.
yes, and there's a criticism made that they're people who mainly work with Dr. Armendariz. Now,
Is that why some of these witnesses are different witnesses?
well, they're all doctors, so we're not doing general reputation, Your Honour. The attack made by Dr. Papadimitriou relates to his reputation amongst his colleagues. And so we have sought to respond to that by calling affidavit evidence from doctors who do not directly work at Macquarie or Norwest, because that appears to be what's being covered.
But this is something I haven't asked before, but it strikes me that part of this case is that it's accepted there are some doctors, for whatever reason, I know you attribute motives, don't agree with your client for whatever reason. Isn't that said to be, Dr. Papadimitriou is one, and there's others that have been named. I don't quite understand why putting more evidence on where there's already evidence on affects that, if that makes sense.
Well, first of all, there's a difference between people not getting along and people having a bad reputation. They're two different concepts completely. And it may well be that there's dislike or there's competition, whether it be commercial or professional. It may be that, like Dr. Stalley doesn't agree with the surgery, but that doesn't mean that the surgeon has a bad reputation as a surgeon when it comes to either his competence as a surgeon or the patient care issue or the sales issue. Now, what we have on bad reputation is limited to Dr. Papadimitriou and his view on that question, and it's specifically directed to colleagues or other doctors who don't work with Dr. Armendariz. And in our view, given that was led without notice, we are entitled to reply to it. And whether we have...
the fact that the evidence to the same effect came in cross-examination.
Yes, about Dr. Papadimitriou's view of my client's reputation in 2011 when he'd been a surgeon for 2 years. It's quite a different category to his reputation over a decade later at the time of publication, and is, frankly, in our submission, pretty worthless. But we'll be making that submission. The evidence we're seeking to address is not Dr. Armendariz' reputation in 2011 when he was a junior burger. It is his reputation in 2022 at the time of publication. And amongst...
Is Berger surgeon when he was a junior burger? Is that surgeon, maybe, by any chance? So, there's this controversial doctor, okay? And the way that he attaches prosthetics is he sort of fuses this metal ball piece onto the bone left. Like, I got my arm amputated. He fuses this metal ball piece onto the bone that's left. Okay? And he does it in a way that's unconventional or newer. It's not the standard way everybody does it. But that's why people go to him. And when I say that's why people go to him, he doesn't perform these procedures just in Australia for Australians. Globally, people come to this doctor to get this procedure done. Okay? And there's been some infections. And it's made it worse for some people. So he has some happy people that, live pain-free with a superior prosthetic because of this procedure. And then there's people who had to get more amputations done because of this procedure. So his opinions on how this procedure is to be done and what you should do, they're very controversial. They just are. All right? He wasn't doing these procedures 2 years in. Like, he became a doctor or surgeon, whatever. And then 2 years in, he's doing this. It took time to develop over the years. So, I can't remember the word that Berger. I think what the plaintiff has brought forward was an opinion that a doctor had on Dr. Papadimitriou when Dr. Papadimitriou was, still just a brand new doctor. And she's saying that when he was a junior burger, it doesn't count. It doesn't matter. But yeah, there was. If you look through these videos on my Patreon, there was this great witness from France, and she had experienced infections, lots of infection issues. And when she would call to get help from this doctor, he's not available. He's not available to help her. And then the other one, you're just going to show my ignorance, but I don't know where. He was in the Middle East somewhere. And he had flown to Australia to get this done, I think on his knee. And he had pretty bad infections. And when he tried to get help, there was no help for him. So that's the problem. I don't know why she said burger. I don't know. That's why I paused it to stop to figure out what burger meant. But it has to be some sort of doctor or surgeon or maybe specialist in this area. I don't know. But Why do you think his name is Dr. Frankenstein? Because that would make sense. Bobby thinks his name might be Dr. Frankenstein, but that might be a joke. I don't know. She said surgeon and I heard burger. I'm going to rewind it just a titch. Just a tiny titch. Of course, there is absolutely no great way to rewind, just a titch on Patreon. So, we're at 23:38. I just rewound it 30 seconds. Hopefully she says it.
Been a surgeon for 2 years. It's quite a different category to his reputation over a decade later at the time of publication, and is frankly, in our submission, pretty worthless. But we'll be making that submission. The evidence we're seeking to address is not Dr. Armendariz' reputation in 2011 when he was a junior burger. It is his reputation in 2022.
She definitely says junior burger. Burger? I don't know. I don't know what that means.
At the time of publication. And Your Honour heard my client's, when I made the application, my client's reaction to that evidence. And it was shocking to his legal team to have that evidence adduced without notice. And we decided, having regard to Your Honour's ruling, which we don't cavil with, that it was important to respond from different sectors of the medical profession, so other surgeons, general practitioners who refer patients, and also some international surgeons, so 3 different sectors of the profession, to support a submission that Dr. Papadimitriou is an outlier in that regard.
You would say that's the case on your own evidence already?
Well, no, because we know that, now we know, we didn't know until we heard the bad reputation evidence, that there'll be a submission that these are people who are somehow commercially reliant on him or work with him, even though they weren't cross-examined. I mean, we don't, otherwise, if my friend accepted their evidence and the respondents accepted my client's good reputation amongst other professionals, they wouldn't have adduced Dr. Papadimitriou's evidence. They say they join issue. We didn't know that. So that's
the aspects of the affidavits which go outside the general reputation.
I'm not quite sure I understand that submission.
Thank you, CJ.
I have concerns.
Yes.
There are specific, what a doctor says an unnamed patient of theirs said to them or didn't say to them.
Yes.
What am I to make with that? That's not general reputation.
It is, Your Honour, that's exactly general reputation evidence. And it's admissible under Section 60A of the Evidence Act as the basis upon which the doctors who are giving that evidence have formed that view.
So it's not being led to say, here's my 5 patients and they've all were very happy with Dr. Armendariz.
Oh, of course not. It's led as reputation evidence, not as the underlying truth of happy patients. Although I'm pretty surprised that my friends challenge that there are happy patients, given that their article apparently says there is.
That's
what the GPs...
That's not necessarily that they plainly accept there are happy patients, but when you're dealing with...
I forgot about the article, guys. A big part of this case was there was a scathing article written about this doctor. It was brutal. It was bad. This lawyer, guys, she goes through every single sentence of this article, sentence by sentence, with every single person quoted in the article. She calls them all in. And we watch her. She's like, you said this. And then she pulls out of the air things about these people's histories that completely is in conflict with what they said in this article. So I think this may possibly be a defamation case, as they wrote this article about this doctor. So I think this might be a defamation case. I really do, now that I'm thinking about it. And what she does with this article and these people is crazy good. It's just, she literally knows by heart every single word of this article and destroys the people who said anything in this article.
Unnamed persons that one would have thought on your case, as you now put it, there would be a limit to the use of the evidence.
Of course it is. All reputation evidence turns on the perception of the witness of the plaintiff's reputation by reason of things that they've seen, heard or otherwise observed amongst other people within that group. And what the doctors are explaining when they refer to patients is, well, I have formed the view that he has a good reputation amongst patients and are happy to refer patients because of the feedback I've got from patients. It's not evidence of the truth. It just explains the reputation evidence. So we don't adduce it for that purpose if that's what my friends are concerned about. And we couldn't, not when it comes to reputation evidence. The next category is the charging of American patients. We had quite a dispute about this when the evidence was sought to be admitted by cross-examination at transcript 412.
Read it.
Quite a dispute.
I reread it recently.
Yes. And the allegation, which is wholly unpleaded, is that my client is behaving in improper conduct by the fact that he requires overseas patients to pay for not just their surgery, but the accommodation and the hospital fees and the other doctors, the anaesthetists, to pay before they arrive. Now, again, you'll see from transcript 412 that genuinely took us by surprise as an issue. And it's clear, and my friends refer to why didn't we adduce evidence from Dr. Armadiris or Ms. Roberts or Dr. Altahir? Well, the first time it was raised was when they were cross-examined. And it's actually apparent from their evidence that they don't necessarily know anything about the visa issue.
Your client was fairly specific ultimately as to the basis upon which the charges,
Yes.
the payment in advance.
Yes, but he was also repeatedly said, I've got nothing to do with that. His understanding was...
Well, are you running a case then that the reason that the payment is required in advance is this?
Your Honour, we don't know what the case is we're trying to meet. We haven't got any pleaded case or any enunciation from anyone as to why it's wrong when someone's coming overseas and can abscond without payment to make them pay in advance. We don't understand what ethical rule is being breached. So we are trying to respond to something that we don't actually know we don't know what's being argued, other than it was put to him somehow that that's not right. Now, my client sought to address it without notice and without talking to us of his understanding, which is, well, I'm worried they'll abscond. I mean, people leave and then I just don't get paid. And I have to pay the hospital and I have to pay the other people. And he also said the hospital won't take the booking unless there's payment. So he gave a couple of reasons based on his understanding. It is clear that Ms. Bosley started that procedure. Not Ms. Roberts or Dr. Altahir knew nothing.
What procedure?
The email that we've seen, which was a document actually we don't have, I should say, Your Honour.
Yes. The email doesn't say anything about her starting the procedure.
No, but it's an email we'd never seen. Your Honour probably has observed that Ms. Stewart and Ms. Bosley often use their personal email addresses. Your Honour will have observed that throughout. We don't have those documents unless they're specifically placed in the file or unless one of the patients has produced them. For example, Ms. Ortiz, in her second affidavit, produced a whole heap of emails with Ms. Bosley that we'd never seen. So there's this tranche of information out there from Ms. Stewart and Ms. Bosley, at least, of communications with patients or about patients that we don't have. Now, the first time we saw that particular email was when it was discovered. But obviously I have to say, notice it particularly until I was preparing Ms. Stewart's cross-examination. And having noticed it and having recalled that this was now something that was being alleged by way of impropriety, we made inquiries and we found out that it was a requirement under the visa laws for a medical visa, that payment be made in advance by the person coming from overseas so that there's no drain placed on the Australian healthcare system. That's what the evidence shows. And I'd be surprised if it's in dispute once my friends have a look at the material. It's pretty straightforward once you look at the Department of Immigration website and the relevant documents. Now, that explains, together with the email, why there was a system that required it before entry to the country as opposed to before surgery. It just explains that discrepancy.
Well,
So I'm not 100% sure what I looked up is the same trial, but I think it is. It looks like partway through this trial, she was taken off of this case because of a conflict. And because she was taken off, the person the plaintiff, who said I was defamed, the doctor, dropped the whole case and dismissed it. So there is no verdict on this.
but that's not your client's evidence.
But there's no suggestion he knew anything about it, Your Honour. Why would he know that? I mean, it was clear repeatedly from his evidence. And again, we had no notice of this, Your Honour. We didn't have time to make inquiries, nor did he.
Well, Ms Roberts was cross-examined. She was the first witness.
Yes.
By the time you got to your client, it was an issue.
Sure, Your Honour, but we kept, from memory, did we keep our client out of court? Our client was out of court for Ms Roberts.
I'm not suggesting he was in court.
No, but what I'm suggesting, Your Honour, is we were very careful so that there was no suggestion made that he altered his evidence to keep him distinct from Ms Roberts' evidence. So we made that as a tactical decision to preserve his credit. So for us to, that's something you can do with your clients. You can have them in court or you don't have to have them in court. Like all the witnesses that the respondents called chose to watch the proceedings. We'll be making submissions about that. We obviously did the
They all
opposite.
did, but anyway.
Many of them.
But
watch some episodes.
it's if a topic that you were taken by surprise about, but was held to be admissible in the first witness of a hearing, it's not a question of whether somebody's sitting in. If you are calling witnesses who thereafter have, you would think, information on that topic to assist the court, you would seek to lead that evidence.
Maybe. I mean, if you had time or you understood it. I mean, he went on straight after her. In fact, I'll have to check.
You don't need to yell at...
Sorry, I'm not yelling.
I understand how trials work.
He was on straight after Miss Roberts.
Sure.
And I'll check the transcript now. I don't know. That evidence might have been the same day that he started. I'll have to check. It was either the day before he started or the same day that he started, because he started just before lunch. So it's difficult to accept...
She was not yelling at all.
Where a topic has taken us by surprise, where we don't even quite understand or really understand at all how it's being put, that we would be expected to get instructions from our client who's about to commence his evidence. I mean,
Listen,
we didn't even have the transcript.
I can yell at the cutest dog. I absolutely can. I'm very good at it. Yes. Yelling at animals? Yes, I'm very good at it. They don't listen. Doesn't do anything. Especially these cats. They don't care.
We had to get the transcript, if it was that first day, I don't know if it was the first day or the second day of Miss Roberts, try and figure out what was being said. Our first port of call would have been Miss Roberts, because she's the one who actually would know more about this than my client. I mean, it's a bit...
Sorry, give
We
me...
say, Your Honour, that's quite unfair, where it's an unpleaded allegation that's never been articulated.
I would be stuck in my room forever if I didn't yell. All I say to all the animals all day long is move, move, move. And I didn't say that the day I fell down the steps because the cat was on the steps. I'm carrying huge trash bags and they just sit right there. Move. That's all I yell all day long. Move, move. It was like when my kids were little, I'm like, go watch TV. Go watch TV, go watch TV. I yell at my cats, move, 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 move. Like I'm saying move right now and they're all probably like...
To expect us to prepare our client for it, shortly after the evidence was given, within hours. So that's what we say about that.
I don't know that you re-examined him on it either.
Re-examined who, Your Honour? Well, I didn't have any instructions. I mean, there's no reason to think. I mean, he answered the question to his knowledge. I'm not sure how re-examination would arise. I wasn't going to tell him what I thought, why I thought it was happening. He gave evidence as to what his belief was, and he'd answered the question. I didn't think there was anything to clear up as far as his understanding was concerned.
Assume that the visa information is admitted. Why?
Okay. It looks like the judge is getting highly annoyed at her, and it looks like in response she is laughing at the judge slightly. It's just pretty hilarious, but can't end well for her if she does that because she's the judge.
About it is meaningless
because some of the forms that he refers to, you can only get if you're a subscriber. So through the firm, they're not available on the website.
He's done more than that. He comments.
Well, maybe some of that's inadmissible, Your Honour, but it's there for convenience to explain how he's obtained the forms. And I mean, it's a submission, Your Honour.
I don't let in evidence for convenience in that sense. If what you say is relevant is the documents, then sure, I clicked on this, I did that to obtain the documents, I get that. But anything that talks about what the documents mean or what the documents require is not for him, is it?
No, Your Honour, but I'll be making the same submission, and my
that
friends
might be
now.
so.
My friend, well, Your Honour, their evidence is full of material like that, including the expert evidence.
Well,
but
it's not tit for tat.
Yes, I accept that.
We're in reply, which is something that I know you keep saying that you're entitled to call the evidence, but is something that doesn't happen necessarily as a matter of course.
We say we are entitled to a case in reply as a matter of course, Your Honour. We don't accept that proposition.
Mr. Stanley, that was to misinterpret. Of course, if evidence is relevant in reply, it is admitted in reply, but it does not mean simply because you get to the end of the respondent's case that people are automatically entitled to lead further evidence. One's attention is drawn to what the evidence is, and if it's relevant, is it all relevant, is part of it relevant, what use is to be made, etc. That's what I was meaning.
Well, I don't think we're disagreeing, Your Honour. If some sentences are a submission or an opinion, then they're not admissible as evidence. They're submission or opinion. Your Honour, the next person is Mrs. Heffernan. Your Honour will, if Your Honour looks at the amended defence, the allegation in relation to Mrs. Heffernan, which is...
Guys, I don't even know if you saw what I saw there. That judge just got highly mad at her. My whole stomach tightened up. Sue just stood there like... She didn't care one bit, not even this much. She's like, Judge, you just said something stupid. And it was stupid. The judge was like, you misunderstood. She didn't misunderstand you, Judge. You said something pretty stupid. And Sue just stood there like nothing. Like, you're going to have to fix it yourself, Judge.
Which is disclaimed by the experts, is that my client used the wrong implant. So Mrs. Heffernan starts at page 77 at particular 342.
Chrysanthemum doesn't care, Brad. She doesn't care one bit. Cool as a cucumber.
And the allegations are about whether risks were notified at 346. The fact that the operation then occurred. And my friends rely on the last sentence of 350. That's not an allegation that my client failed to test the stability during an operation.
So we do learn something huge from this whole trial that we watch. If an Australia calls you their friend, yo, that's not a compliment. That's not and what my friend here means is there's no compliment going on there. That's a negative. They're making fun of you in some way.
And negligently perform the operation for that reason. And in fact, when it comes to the particulars of negligence, at paragraph 369 at the bottom of page 81, the negligence is identified. And this is how we, with respect, understood the difference between background facts and actual allegations. The negligence is that she wasn't a suitable candidate, or he failed to assess whether she was a suitable candidate. That's clearly not maintained by the expert evidence. That he failed to disclose the risks, and informed consent, which go together, and D, that he used an inappropriate implant. Now, that's disclaimed by the experts. They say the implant was fine. Now, then, that he failed to diagnose that the implant had slipped. That means that it was in place and that it later slipped. And we wholly understood the lay evidence of Dr. Lyons to be that he identified instability 8 months later. And then the post-operative care allegation. We then had, through the new material from Dr. Ruff and Dr. Lyons this year, not only an allegation that he didn't test the stability and it was unstable at the time, but another allegation by Dr. Ruff that if he must have seen those figures and he deliberately left it unstable. That's what Dr. Ruff says, that those figures are so clearly indicative of instability that he must have known it was unstable and didn't bother to fix it. That's what his expert report said. Now, Dr. Lyons was not an expert witness. My learned friend referred to the fact we had expert evidence from Dr. Lyons. No, we didn't. He was only put forward as a lay witness. We didn't have, as part of his evidence until this year, his operation report, nor did we have his subsequent letters about what happened with Mrs. Lyons. I called for those when he was in evidence. We had the first two, but not the subsequent ones. He gave evidence, which Your Honour heard we cross-examined on, was ridiculous in relation to that spreadsheet. We say, given when that affidavit was served and given he didn't accept it, we're entitled to put on evidence proving that it is ridiculous.
The Rosa material?
His interpretation of the Rosa material...
Not, as I understood it, it's not an issue that anything to do with the Rosa. Isn't that correct?
Well, no, there's still an allegation maintained.
No. As I understood it, and the respondents will correct me if I'm wrong, objections not being taken to any of the evidence in reply in respect to the Rosa.
In respect of the interpretation of the spreadsheet. That's my understanding. And how the Rosa works. Yes, but they still maintain an allegation.
Well, but why are we then arguing about the Rosa?
Because that leads up to the allegation they maintain, which was that the knee was unstable during the surgery and that my client did not test stability. They maintain that. And Ben Edwards, first of all, the operation report says they did test stability, and Dr. Stoiter refers to that. Dr. Stoiter clearly refers to the fact that there's no...
Well, if Dr. Stoiter said that they tested it, then why is this reply?
Because of Dr. Ruff's new report and what Dr. Lyons says now by way of expert evidence he detected, and the conclusion that it must have been unstable from the outset, not some slippage that occurred later.
Sorry, just pausing there, just correct me if I'm wrong. I understood Dr. Ruff's evidence was that in respect to the Rosa, he accepts it's possible that it might be recording a different time. And so he put that aside in effect. His answers were based on, because his answers are in the first affidavit, are based on the other material.
Yes, Your Honour. And
not the Rosa.
Yes, Your Honour. And we are calling evidence from Ben Edwards, who has done hundreds, if not thousands, of these operations where he operates the robot, to say stability was in fact tested.
Well,
And that's
the
what they
ROSA.
object to.
As I understand, that's the ROSA. Is that
No, it's not, Your Honour. It's not captured.
no? As I understand it, there is no objection taken to the evidence in reply about the use of the ROSA.
No,
is that right?
That's not correct. My learned friend objects to the observations of Mr. Edwards during the operation. That's what I'm talking about. So Mr. Edwards, who's a technician on the ROSA, the evidence in dispute is what he observed they did using the ROSA during the operation. And his evidence...
That had been given earlier, actually.
Because there was no allegation that Dr. Armadiris left the knee unstable at the time of the operation. The clear allegation in the defence is that it slipped later. It was not a case we were here to meet. We were here to meet wrong size implant. So Mr. Edwards is present in the operation. He's operating the robot. We anticipate his evidence will be, we tested stability using the robot. It just wasn't recorded. And so the notion that instability was ignored by my client negligently, which is the new case that's now put, we find it remarkable, given the change in the case, that my friends object to us meeting that claim.
I don't care if you find anything remarkable. It's whether or not...
It would be so unfair to not admit that evidence when my client is now being accused of professional negligence as a surgeon by leaving a knee that was so unstable it must have been obvious to him, such that it was deliberate. That's what Dr. Ruff has said. The next evidence...
Where does he say it's deliberate?
His most recent report that was served, where he...
That relates to the ROSA, doesn't it?
But it also, Your Honour, relates to and combines with the evidence he's already given.
He didn't have the ROSA when he was expressing his...
I get why the judge is just so testy, because she keeps speaking in a condescending tone to the judge. Like, I can't believe you just said that, Judge. Obviously, this is what this means. So I get why the judge is getting her back up against the wall. And it's just, it should not work. You should not be able to treat a judge like a judge is a 3-year-old and get away with it. But look at Sue's face. Sue does not care. She does not. If the judge is going to say something that sounds like a 3-year-old said it, then she's going to be treated like a 3-year-old.
Opinion in respect to the first report.
Yes, we accept that.
So he's made a concession in respect to the ROSA.
Yes, they were given the ROSA material in August. We accept that, after they did their reports.
After they did their reports. So what the trouble I'm having is, it seems to me you're trying to lead evidence in reply in this respect when the evidence was there from Dr. Ruff beforehand, and you're now relying on the evidence of a later report, which he's conceded without taking into account his concession. So he's already expressed the view in terms of the...
Well, he said maybe. He said maybe, Your Honour. He didn't accept it wholly.
His first report, he says, knee's unstable. Is that right or wrong?
Well, he said it's unstable at the time Dr. Lyons saw it.
His first report doesn't say unstable at the time.
I'll just double check
Question,
that.
as I understood...
I'll just get that up.
It seems to me, in respect to this aspect, at least, in respect to relying on Dr. Ruff, you're trying to bring in, where you've already led evidence of expert evidence in respect to Ms. Heaverton, bring it in on the basis of the ROSA when the opinions had been expressed before.
Your Honour, point 1, it's not pleaded. Point 2,
I understand that
we
point.
objected to it because it wasn't pleaded, and we maintain those objections.
I understand that point too.
Yes. Right. So at the time we served our evidence, there was no pleaded allegation that my client had deliberately ignored the stability during the operation.
But when does he say it's deliberate? And does that relate to the ROSA?
Yes, it partly does. It relates to the spreadsheet. But he accepts in cross-examination maybe the spreadsheet is at a different time. He doesn't accept it definitively. So his report is still in on the basis that he's looked at the spreadsheet, right? He accepts maybe it wasn't taken at the relevant time. But if it had been, then it's so negligent my client clearly deliberately ignored the instability. Yeah, so he gives one sentence at the bottom of page 38. He concluded the operation without detecting instability before final implantation while under general anaesthesia. We understood that to be an allegation that he didn't capture it, not that he didn't check it, or that he, well, we didn't know. It was one sentence, unexplained. And given it wasn't pleaded, that was where it was left. But we have before Your Honour, subject to the submissions we're going to make about those reports and objections and the lack of expertise of Dr. Lyons, evidence that was admitted 9 months after it was due by the respondents on an unpleaded allegation. We seek to respond to that in a manner which we see fit. And the tactical decisions we make when we first see Dr. Ruff's evidence, based on the information we have, and the tactical decisions we make now, based on the whole amount of new evidence, Your Honour can't even speculate the reasons why we did things. Because once there's new material on a topic, our decision-making changes. That's necessarily so. And my friends are seeking to restrict us in a way that is impermissible because it fails to take into account decisions made based on what we were faced with at the time, which has now changed. Dr. Vahul, some of that was conceded by my learned friend. And in relation to what has not been conceded as relevant.
It's because she's a beast.
So we understand what's conceded is A, I, and J.
There was 4.
And K, thank you. There you go. So I'll just start with B and C. So in relation to B, because there was no allegation in the pleading about initial instability, we've answered that.
Well, but Dr. Stoiter answers the question of instability. There's a whole material, a whole lot of his evidence in the report. His expert report is on the question of instability.
And since Dr. Stoiter was cross-examined, a new expert report has come in from Dr. Lyons that we are seeking to respond to. Your Honour has Dr. Ruff and Dr. Lyons. We are responding to Dr. Lyons. A new expert report that came in March this year.
But that relates, the one in March relates to the Rosa.
No, not only, Your Honour. Dr. Lyons goes on to say, this confirms everything I thought, that it was unstable from the beginning and what I found in my operation. He draws it all together.
No, he says, here's my original report, which you've not answered.
Yes.
He then does a...
Well, that wasn't a report, Your Honour, was it?
Or whatever.
Evidence. Yes.
Then there's the Rosa material. He says, oh, I've got that. This confirms that.
Yes, but now it's coming in as expert opinion as to the state of the knee at the time of my client's operation, which it wasn't before. It was lay opinion as to what Dr. Lyons observed in July and what he observed during his operation. It only came in as lay opinion of his observations. He has now been transformed into an expert. He's giving opinions that based on his observations, the original surgery was done incompetently and the knee was unstable at that time. That was not his evidence before because he wasn't being called as an expert. Now, he has not stepped back. Despite me putting it quite directly to him, he has not stepped back from his interpretation of the Rosa. So even though Dr. Ruff has, Dr. Lyons has not.
But the Rosa material is on at least the questions or the assumptions that is not objected to. That relates to the Rosa. What's objected to it, what's said to be matters outside
But they arise from the ROSA. Dr. Lyons then gives evidence based on that material. We're responding to that, including by, as I put to him, identifying the presentation of Mrs. Heffernan from time to time in that period to demonstrate that his conclusions are nonsensical. We're entitled to do that. He's come to the court without notice in March and expressed a view to Your Honour, based on a number of factors, including the ROSA, that the knee was unstable at the outset. We are answering that.
Is that not in his original report?
It's not a report, Your Honour. It was lay evidence.
Hey, was it in his original affidavit?
No, he says that the operation confirms what he believed in July, which was instability, not that it meant it was unstable at the outset.
No. The original evidence of Dr. Lyons, not the one just before the last tranche.
Yes. No.
Does he say, he talks about instability?
Yes, at the time he saw her in July.
Does he comment one way or the other as to whether his view is that the instability had been there for however long?
I don't think so, Your Honour, but Mr. Olsen's double checking. My recollection, and it's being checked, is that he comments on the fact that his operation, when he opened her up in...
I forgot, and they say it over and over again. In what we covered of this trial back in 2024, it was 60 minutes. 60 Minutes did a piece on this doctor. So this doctor is suing 60 Minutes. She was the lawyer until she was removed from the case because of a conflict.
November confirmed the instability he suspected in July, not going back any further. And Your Honour's heard...
I don't know, I was asking.
Yeah, we're just double checking.
And this was one of the longest running defamation cases in Australia.
He first saw it in July. He formed the view that it was unstable. All of the scans were acceptable, which he agreed also when I asked him about those. He explored the exploratory surgery, found it was unstable at that time in November. That's all he says. He doesn't even actually date it back to July. He just says on 11 November, he found it to be unstable. So a year later. As I said, we weren't going to cross-examine Dr. Lyons, that one, based on that evidence.
Channel 9 is the one that got sued.
Sorry, paragraph 15.
15 of the affidavit says it's through surgery.
Yeah.
Take the money.
Isn't that what I just read out? Sorry. Yeah. I think we're agreeing. Now, in the circumstances where there's now a case that it was unstable from the outset, we are putting on expert evidence as to the reasons why Your Honour wouldn't accept that, including her presentation throughout that period, which I put very clearly to Dr. Lyons and Dr. Ruff. So they've had the opportunity to answer those questions. And Your Honour will no doubt recall, given how long the cross-examination of the experts took, at no point did I cut off any expert or not give them the full opportunity to explain their views and why they thought things. So they've had the opportunity to give their opinions on these matters, which is relevant because we don't think there truly would be anything that could be led in answer to this material. Leah Mooney, this is, I've already referred to this in the context of Dr. Papadimitriou and Dr. Ruff, but new material's been adduced that we didn't have served at the time that the expert evidence was being prepared in June and July last year. And it's been allowed in through the affidavits of Dr. Papadimitriou and Dr. Ruff as to a number of x-rays, the intraoperative scans of Mrs. Mooney, and in the first affidavit in February this year of Dr. Papadimitriou, a series of paragraphs that I objected to about where he sets out the chronology to confirm his views about the infection and how long it had been. So the new evidence addresses not only the competency of the first surgery, but also whether the infection should have been detected. And we say that we're properly responding to that. And in relation to the opinions expressed the negligence that's identified in the defence about Mrs. Mooney is specifically leaving the drill bit. So in relation to Mrs. Mooney, there's an allegation that it was negligent to leave the drill bit in during the first surgery.
What about that?
Your Honour will recall that no doctor agrees with that. They all accept that that happens. But as to the term whether the surgery was properly managed, we understood that, given there was no allegation to the contrary, other than the drill bit, to be an allegation that he didn't proceed using the correct procedure or the correct method. That's what we understood. And now there are very specific allegations, and Your Honour, Dr. Ruff very properly, in fact, abandoned many of the complaints he made about that surgery. And it seems to us the real factors in issue are the size of the plate and the placement of the plate.
So I also want to show you some of her actually questioning one of the witnesses, but this is one of the people I think that said something. So it was on 60 Minutes, but it was in this article. And she pulls apart every sentence of this article in the trial. Again, I have 20 hours of her in court. And I think this is one of the people who said something in this article, but I am just not 100% sure. But I want to show you her questioning one of the witnesses so that you can see how she acts when there's a witness on the stand and how she treats them and how she questions them, because it's really brutal. I mean, it's so good. So here, let's listen to her question this guy for a tiny bit.
You met Dr. Richard Beaver at some point?
Yes.
And he performed transfemoral osseointegration on your leg in 2013? Feel free to have a look at your at the timing.
I don't know what the date was, but yeah, he did do that to me.
So paragraph 10.
Yep.
You said about 20.
Yeah, if it was 2012.
Yeah.
Yep.
I think you're saying you first saw him in 2012, and it took a number of appointments and months.
Yeah, it did take a while. Yeah, for it to happen.
And you had the German designed ILP system.
Yes.
And that was a system which required surgeries in 2 stages.
Yes.
So you had one surgery and then another surgery a few months later.
Yep.
And you've said that, just for the dates, you've said that in 13 and 14 of your affidavit, if you want to follow on there. Did you have a couple of, after getting your transfemoral osseointegration, did you have a couple of falls?
I had one fall, and the other one I'd sort of put a lot of weight on it and rotated a bit too fast. And
Ouch.
Sheared the pin.
Where's her little bow? Didn't she have the white little bow that looked like a little arms and little legs coming down? It's gone now, or it's hidden because her robe is more fully open.
So in 2014, there's a record that you fractured your mandible after a slip and fall. Do you remember that?
Yes, I do.
Yeah. And was that something to do with slipping off on your osseointegration leg, or?
No, it was just because the floor was wet. Where I was, it was in Melbourne near it just rained, and then there was tiles. I didn't notice the puddle, and I've stepped on that and slipped and hit my head.
Yeah, and you sort of break part of your jaw.
Yeah.
And then in 2016, you had a meniscal tear in your other knee, in your right knee. Was that an injury that had happened?
Where's this?
You say in paragraph 16. So you talk about minor falls.
Yep.
Do you remember how you tore how you got an injury in your knee, your right knee, in 2016?
I think I hyperextended it. Yeah.
Now, do you recall, and you say this in 17, you first met with prosthetist Brendan Cahill
Yep.
on 10 October 2016. So did you change? So you wanted to try a new prosthetist at that point?
Yes. Yeah.
And previously, had you had other prosthetists in Perth in
I'd
relation
been
to leg?
going to a different company. Yeah. I met Brendan at that company at it was like a quorum of prosthetists, and we had a chat, and he had his own sort of company that I'd heard good things about, so I decided to change to a private company instead of a public one.
Now, as at 2017, as you've already said, you didn't have any prosthetic arm and you hadn't had one for about 12 years.
Yeah, that's correct.
Now, is it the case that as at 2017, you were not able to work because of your inability to wear a functional prosthetic arm?
Yes.
Now, do you recall, I'm now going to ask you about June 2017. I think you've just told us that you had a problem with your osseointegration leg where you twisted and a piece of the metal locked and was unable to be removed.
Yes. Yep.
And Dr. Beaver was unable to remove it.
That's correct.
And your prosthetists were unable to remove it.
Yep.
And they told you that Dr. Armadiris happened to be in Perth and
Brendan, my prosthetist, said that there was another surgeon from over east that might be able to take a look at it for me if I was willing to come into to his rooms.
Yeah, and you went in and you met Dr. Armadiris.
Yes.
And he was able to remove the part.
Yep.
And you took some videos of that happening.
Yes, I did.
And Mr. Veering was there with you as well as this occurred.
Yeah, Brendan was there. Yes.
Yeah. Now, have you had a chance to review those videos?
I remember them.
Because you've said in paragraph 20 in relation to this process that the friction from the grinding caused the metal in the implant to heat up and cause pain to your skin and flesh.
Yep.
I want to suggest that you've misremembered that and you didn't feel any pain to your skin or flesh.
No, I did feel pain. It wasn't so much to the flesh, but more in the inside, in the bone. That's why I instructed Brendan and other people in the room to get some paper towel and wet it.
She does that to every single person she questions. They say something in a deposition or in an article or something, and she's like, I'm going to suggest that you misremembered that. And that is not at all what really happened. And she says it just like that. That never happened. This never happened. And like she browbeats them into saying, oh, well, I guess it didn't. I guess I was wrong. I guess that didn't happen.
To cool down the
It's
metal.
really good.
Right, and do you
Really
remember
good.
seeing on the video Dr. Armadiris kept checking the heat of the rod as he was using the grinder to make sure it wasn't heating up too much?
I don't remember that part, but yeah.
And you say there that you had to tell Dr. Armadiris to stop at various intervals because of the pain. I want to suggest to you that
You need to say,
Oh,
nodding doesn't go down on the
Sorry,
transcript.
sorry.
No, no problem.
Yes, I did, but a lot of the times I did actually have to instruct him to stop as well. The video that I took wasn't really that long. We were there for quite a while. We actually ended up going through 4 Dremel discs.
But you're not suggesting, are you, that Dr. Armadiris was intentionally causing you any pain?
He wasn't intentionally there to cause me pain, no. He was trying to remove the locked bits of metal for me, yes.
And to your recollection, where you've said that you asked him to stop at various intervals, he did stop, didn't he?
Yes, he did, yes.
And you were very pleased, weren't you, that he'd managed to fix that part?
Yeah, that he was able to get that component off, yes.
And he didn't charge you anything for that, did he?
No.
Now, you talk about a conversation, and you give evidence of some conversations in paragraph 21 and 22. I'll just let you have a look at those so you remember what I'm asking about. I want to suggest to you that you're incorrect in your recollection that Dr. Armadiris asked anything about who was covering your medical expenses.
No, that's incorrect.
And
He asked me if I had insurance, and I told him I did, that everything was covered through my insurance.
and that he never told you that he thought you could actually have the osseointegration surgery.
Say that question again, please.
He never actually said anything to you to the effect that he thought you could in fact have that osseointegration surgery on your arm?
No, he suggested it straight away. He actually asked me why I didn't have one already. I explained to him that I have looked into it, but there was no one in the country that would do it. And that's where he said that he actually was one of the surgeons that could actually do it for me.
So where had you looked around before then? Had you asked around?
I just researched online. Yeah.
And you couldn't find any other surgeons who...
I'd asked my actual surgeon as well, that Dr. Beaver, about it, and he said there's no way that anyone would do that.
So he had never done an arm?
No.
Right. And did you have any contact with any of the... did you have any... Or in your research, did you find people in Melbourne who did arms? You didn't see that? Right. And you say there at the end of paragraph 21 that Dr. Armadiris showed you videos of kids?
Yes. No, not of kids. It was a video on his phone of a young man that actually had an arm attached that was apparently being controlled by nerve endings.
So a myoelectric
arm with being controlled by nerve endings. That's what he explained it to.
Okay.
How he explained it to me.
But it wasn't videos of children?
Not children, no.
Yeah.
No.
So you think that he explained to you that it was possible to get an arm with osseointegration where your nerves help control the hand?
That's correct.
Yeah. Now, you then went and did some research about that, as you say in paragraph 23. And you then organised to see Dr. Armadiris, is that right?
Yes.
And did you, I want to suggest to you that before you saw Dr. Armadiris, you discussed with your prosthetist in Perth the possibility of having transhumeral osseointegration and a myoelectric arm affixed?
I spoke to them briefly on it. Brendan said it would be definitely a different option of the way that the arm could connect to me.
Yeah.
So.
And he suggested to you, didn't he, that you'd have a much better chance of getting myoelectric arm on with osseointegration than you could otherwise?
He did say it would be interesting to see what would happen with an osseointegrated attachment for an arm. Yeah.
And you also discussed osseointegration, didn't you, with your physiotherapist?
Not that I can remember.
And do you recall your physiotherapist saying that a prosthesis on your arm should be more possible with osseointegration?
Not that I can remember, no, but it's the way it was. When I was talking to anyone in regards to my getting a prosthetic arm, it was all about the way that it was actually going to be attached to my body. Just like the leg, with the osseointegrated connector, it was just a much easier way for me to attach the limb. And yeah, so in that respect, everyone was saying, yeah, it would be beneficial to actually try that well, it should work better than the ways that I have been experimenting with straps and things like that.
And do you recall that at the time you were seeing a physio because you had neck pain because of the fact that you didn't have an arm on, and it was referring neck pain up because you were a bit uneven?
I had a lot of pain everywhere, so yeah, I was seeing physios for different types of pain, yeah.
And do you remember being told by your physio that being able to affix an arm to your left remaining humerus would likely assist with the neck pain you were having because of the
Really,
weight?
No.
Now, do you recall before you saw Dr. Armadiris, so Dr. Armadiris, as you say at paragraph 25, you saw on 14 April 2018. So it was well over 6 months after you met him when he fixed that part for you. Before you saw him in April, do you recall in March 2018, and I think this must have been with Dr. Beaver, you had a scar revision of your left leg amputation? So about a month before you saw Dr. Armadiris. It's not in your chronology there.
Okay. Not really a scar revision.
Do you remember having a procedure with Dr. Beaver in March 2018 on your left stump?
Had a lot of procedures with him. I don't really remember the specifics of a lot of them.
Well, do you remember that at the time you saw Dr. Armadiris, you were on antibiotics because of an infection that had arisen as a result of that scar revision?
No.
I'll just show you and I'll come back to that. I think it's slightly out of order. Now, on the 14th of April, as you say in paragraph 25, you saw Dr. Armadiris with a few other people. And your prosthetist was there, wasn't he, Andrew Veering?
Okay, and then, listen, we're already an hour and a half in.
Do you remember other people being there?
There's one more person I want you to see because she's lovely. She's from France. And she's in here a couple times. There she is. And she's being questioned by Sue, and she's in her home in France. And it's funny because they go for about an hour in this trial. They go for about an hour, and then it's like, okay, we're going to take a break. So she's not used to that. So they go for an hour, and the judge is like, okay, it's time, we're going to give you a break. And she's like, a break? We just started. I don't need a break. And every time they go on break, there's someone else in the room with her, and I don't know who it is, maybe her husband. Like, she's like making fun of the court for giving her a break when they just started. Let's see if I can start at a good point where Sue is talking. Look, okay, she does eat a lot during the breaks. She's constantly snacking on cheese and crackers and stuff. And you can just imagine her being in France, that what she's snacking on has to be freaking delicious. She's just lovely. She's lovely. Here we go.
Ve belinizde çok ağrı hissettiğinizi ve özel ilaç aldığınızı söylüyorsunuz.
Evet, belime bir anestezi bağlanmıştı.
Yeah, so I had anesthesia attached to my back.
And do you remember you, in fact, because of that anesthesia, had to stay in hospital an extra 2 days?
Ve bu anestezi yüzünden hastanede 2 gün daha ekstra kalmanız gerekiyordu.
Ekstra kalmadım ben. Verilen süre zarfında kaldım hastanede.
I didn't stay extra days. It was the required amount of period.
You don't remember that you were supposed to leave on the 15th, but you left on the 17th?
Ya hatırlamıyor musun? 15'inde çıkman gerekiyordu hastaneden aslında ama 17'sinde çıkartıldım.
Çok hatırlamıyorum ama şeyi hatırlıyorum. Daha fazla kalmak istemiştim. Bunu talep ettiğimi hatırlıyorum. Yoğun ağrılarımdan kaynaklı.
I don't remember much, but I do remember requesting to stay a bit longer because of the discomfort I had.
Yeah, and you've said in your affidavit, paragraph 32 to 34 that you talked to Dr. Armadiris about that.
Ve beyannamende paragraf 32'den 34'e kadar Doktor Amediris'le konuştuğunu yazıyorsun.
Evet, ona sordum. Daha fazla
Yes.
kalabilir miyim hastanede diye.
Yes, I did ask him if I could stay a bit longer in the hospital.
And I just want to suggest to you that your recollection of what he said to you about that in paragraph 34 is not correct.
Şimdi ben şunu söylemek istiyorum size. Hatırlamanıza dayanarak paragraf 34'te yazılan şeyler yanlış.
Hayır, yanlış değil. Ben onu söyledim tabii ki de.
It's not wrong. I did say those things.
Yes, but he didn't tell you that you had to leave the hospital because it was going to cost more.
Ama tamam da o size hastaneden çıkmanız gerektiğini söylemedi. Çünkü hani daha fazla kalırsanız daha masraflı olacak diye yazıyor ya, onu demedi size.
Evet, tabii ki söyledi.
Oh, he definitely did say that.
And if you please look at paragraph 32,
Paragraf 32'ye bakarsanız
you did not, you're mistaken about your recollection that you had a fever.
Şimdi bakarsanız o paragrafa ya bir hata yaptınız, çünkü hatırlamanızda ateşiniz yoktu.
Ateşim de vardı, ağrım da vardı.
I had a fever, I had pain.
Muhtemelen kendisinde doktor o dönemin epikrizleri var şu an. Ateşimin kaç olduğunu bilmiyorum. Ama yoğun vücudumda bir yanma, bir ağrı, özellikle bel ağrım çok şiddetliydi. Anesteziden kaynaklı. Hepsi mevcuttu.
So there was doctor's epizedia, there was burning, there was pain, there was back pain, and the back pain was as a result of the anesthesia.
Yes, I'm not disputing that you had pain after the surgery. What I'm suggesting to you is that you're incorrect in your recollection that you had fever.
Yo, ben ameliyattan sonra ağrılarınızdan söz etmiyorum. Sadece hani ameliyattan sonra ateşiniz çıkmadı. Onu söylüyorum.
Ya bunu neye dayanarak söylüyor?
I don't know why you're saying that. Where are you getting it from?
I'm just suggesting to you that it's incorrect. You did not have fevers while you were in that hospital after your operation.
Ben şunu öne sürüyorum. Diyorum ki hafızanız yanlış. Hastanedeyken ateşiniz hiç çıkmadı.
Ateşim vardı ve bana ilaç veriliyordu o hastanede.
I had a fever and they were giving me medicine for it.
And I want to suggest to you that the bones of your legs, as you describe in paragraph 32, were not visible.
Bir de paragraf 32'de yazılı olduğu gibi bakarsanız oraya bacaklarınızdaki kemikler görünmüyordu.
Tabii ki kemiğim görünüyordu. Sol bacağımda kemiğim görünüyordu. Ameliyattan sonra kemik hafif dışarıdaydı.
Oh, it definitely was, especially my left leg. You could see the bone on my left leg.
And by the time you left the hospital a week after the surgery, your pain had reduced a lot.
Bir hafta sonra, hastaneyi terk ettikten bir hafta sonra ağrın bayağı azaldı.
Ağrım o kadar da azalmadı çünkü çok şiddetli ağrılarım olduğunu hatırlıyorum. Özellikle otele gittiğimde gece boyunca ağladığımı çok iyi hatırlıyorum ağrılardan kaynaklı.
I did have pain and it didn't reduce, especially when I went to the hotel after discharge. I was crying a lot from the pain.
Yes, and I'm suggesting to you that your recollection's incorrect.
Bunu öne sürüyorum. Senin hafızan, hatırladığın şey yanlış.
Yani yanımda değildi, özellikle otelde ve hastanede nasıl buna kanaat getiriyor bilmiyorum ama insan yaşadığı ağrıyı bütünüyle nasıl geliştiğini hatırlayamayabilir olayları ama sana geride kalan insan psikolojisinde duygusudur. Yaşadığı ağrının duygusudur ve ben o duyguyu hiçbir zaman unutmuyorum. Halen o duyguyu taşıyorum.
Well, you weren't there with me at the hospital or at the hotel, so what I can say from memory, I did feel pain. I suffered the pain, and my memory, the feelings, I do recall those feelings.
Do you remember the day you left the hospital, you saw Dr. Armadiris in his office?
Hastaneden çıktıktan sonra Doktor Armadiris'i gördüğünüzü hatırlıyor musunuz?
Ben orada olduğum süre içerisinde totalde 2-3 kere yani birkaç kere gördüm Mucit'i ve tam tarihlerini hatırlamıyorum ne zaman gördüğümü.
I did see Dr. Munjit a few times, but I can't tell you the exact dates.
And do you have any recollection now about the things you discussed with Dr. Armadiris the few times after you saw him when you left the hospital?
Hastaneden ayrıldıktan sonra Doktor Munjit'le konuştuğunuzda anımsıyor musunuz neler konuştuğunuzu?
34. paragrafta Doktor Mucit hastaneden ayrılmadan önce 34. paragrafta bunları konuştuğumu hatırlıyorum ve daha sonra sanırsam uzun bir zaman görmedim Mucit'i. O çok tarihini hatırlamıyorum yani.
So at paragraph 34, before leaving the hospital, I do recall, talking to Dr. Munjit, but a long time after that, I didn't see him.
Well, yes. What I'm suggesting to you is you saw him the day you left the hospital, soon after you left the hospital.
Hastaneden ayrıldıktan sonra kısa bir zaman sonra Doktor Munjit'le görüştün.
Hatırlamıyorum kısa bir zaman sonra mıydı? Çünkü otelde kaldım. Hatırladıklarımı sadece söylüyorum size.
Because I was at the
Otelde
hotel.
kaldım. Tekerlekli sandalye kiraladık ve her gün hastaneye gidip geldim.
We hired a wheelchair so I can go to the hospital.
Was it a wheelchair you hired or I think a three-wheeled scooter?
Kiraladığınız şey tekerlekli sandalye miydi yoksa 3 tekerlekli scooter miydi?
3 tekerlekli scooter. Ben tekerlekli sandalye diye ifade ediyorum genellikle.
Yeah, I always refer it to as a wheelchair, but it's actually a three-wheeled scooter.
And do you remember hiring that from a man who owned a gym nearby called Mitch?
Ve bu scooter'ı
So maybe I was wrong. Are you saying that's not French? Is she in a different country? Anybody know what country this lady is in? I don't know why. Like, this was from 2024. I don't know why I'm saying she's in France. I don't remember why I say that. So maybe I'm remembering wrong. Does anybody know what language she's speaking?
bir kişiden kiraladığını hatırlıyor musun?
Bunu sanırsam oraya gitmeden önce tam Doktor Solo'nun yönlendirmesiyle kiralamıştık onu. Eski bir hastalarıydı, öyle hatırlıyorum. Bir bacağı, o da entegre ameliyatıydı. Yani hafızam şu an bana bunu söylüyor. Ondan kiralamıştık.
I think it was someone that Dr. Solon knew because that person had surgery as well, and they had a gym, and he referred me to him.
Do you remember Dr. Armadiris telling you shortly after you left the hospital that he thought that your legs were healing very well when he looked at them?
Hatırlıyor musun Doktor Armadiris seni gördüğünde, yani kısa bir hastaneden ayrıldıktan kısa bir zaman sonra muayene ettiğinde bacaklarının iyi olduğunu söyledi sana?
Ne zaman beni gördüğünü hatırlamıyorum.
I don't recall when he saw me.
But do you recall
Tekrar
him?
söylüyorum.
I'm
Tekrar
repeating.
söylüyorum. Mujit'i orada olduğum süre içerisinde birkaç kere gördüm ve tarihlerini net hatırlamıyorum yani.
I'll say that
Hafızamda
again.
en
I
canlı
did.
kalan şey hastanedeki konuşmamdı onun.
So I did see Manjeet a few times, but I can't tell you exact dates. But what's etched in my memory is what the discussions I've had at the hospital.
Yes, and I'm just trying to see if you remember other discussions, putting aside the date.
Tamam, tarihleri boş verelim. Yani diğer görüşmelerinizi hatırlamanız için soruyorum.
Do you remember him telling you that it was very important for you to be active and to load onto your stumps?
Ve şunu hatırlıyor musun? Sana şunu söylemişti. Çok aktif olman gerektiğini ve ağırlık koymanı, bacaklarına ağırlık koymanı, yani yürümeye çalışmanı söylediğini hatırlıyor musun?
Çok hatırlamıyorum ama bunu söyleyen o değildi. Başka biriydi, onu hatırlıyorum.
Not
Macquarie
much.
Hospital'a her gün gittiğimde gördüğüm 2 tane fizyoterapist vardı. Onlar bana bunu genellikle söylüyordu.
I don't remember much, but I don't think it was him because I was seeing 2 physiotherapists and they were repeating that a lot to me.
Now, do you remember that you saw? Do you remember seeing Dr. Amadeus about a week after you left the hospital?
Bir hafta hastaneden ayrıldıktan bir hafta sonra Doktor Amediris'i gördüğünü hatırlıyor musun?
Çok hatırlamıyorum.
Not much.
Do you remember that Dr. Solon arranged for you to stay at the rehab hospital for 4 weeks?
Doktor Solan sizin rehabilitasyon bölümünde 4 hafta kalmanızı organize etti.
Evet. The
Yes.
Hills Hastanesi'nde.
Pardon?
The Hills'te.
The Hills, at the Hills Hospital.
Yeah. And you were there from the end of October for a month. Is that right?
Ve Ekim'in sonundan başlayarak bir ay kaldınız orada.
Sanırsam öyleydi, evet.
I think
Bir aya
so,
yakın
yes.
kaldım hastanede.
Yeah, close to a month in that hospital.
And while you were there, the prosthetist fitted your new legs.
Ve oradayken prostetist doktoru protezinizi taktı.
Evet, orada ama hemen takmadılar. Sanırsam bir 10 gün sonra falan takıldı.
Not straight away, so I think about 10 days afterwards they did.
And by the time you left the hills, you were using your new legs.
Hills'ten ayrılırken kendi yani bacaklarını kullanmaya başladın.
Evet.
Yes.
Yavaş yavaş takmaya, günde 1 saat, 2 saat protez takmaya çalışıyordum.
Yes, I was slowly putting on the prosthesis 1 to 2 times a day.
Do you remember in the middle of about halfway through your stay at the hills, you went to the hospital?
Hatırlıyor musun The Hills'teyken bu sürenin yarısı zamanında hastaneye geri döndün.
Evet, ya hangi hastaneye? Özel bir gece özel bir hastaneye kaldırıldım.
Yes,
Ateşim
I did
çıktığı
go
için.
to a private hospital because of the fever that I had.
Yes, and you've talked about that at paragraph 37 of your...
Paragraf 37'de ondan söz ediyorsun.
Evet.
Yes.
I want to suggest to you that your recollection is slightly incorrect. You did go to the hospital, but it was not for infection or fever.
You big fat liar.
Ben şunu öne sürüyorum. Senin hafızan yanılttı seni. Ateşin yoktu hastaneye gittiğinde.
Niçin peki gittim hastaneye?
So why
Antibiyotik
did
tedavisi görmeye başladım sonrasında.
I go to the hospital? When I went to the hospital, I was treated with antibiotics.
Do you recall that the reason you went to the hospital is because you were in some pain and you had a panic attack?
Hastaneye gidiş nedenin çektiğin ağrılar ve panik atak yaşadın.
Panik atak değildi, bir ateş vardı. Neredeyse bilincimi yitiriyordum. Yani.
It wasn't panic attack. It was high fever. I was losing my consciousness.
Do you
Kendi
remember?
hissettiğimi söylüyorum.
This is what I was feeling at the time. That's what I'm saying.
Yeah, do you remember Dr. Rosenblatt told you that he thought your discomfort was psychological?
Doktor Rosenblatt'in sana şunu söylediğini hatırlıyor musun? Rahatsızlığının psikolojik olduğunu.
Hayır. Yani
No.
ben hastaneye gittiğimde antibiyotik verildi bana.
I went to the
Geri
hospital.
döndüğümde
I was given
birkaç gün
antibiotics,
antibiyotik tedavisi gördüm.
and when I returned, I received antibiotics for a few days.
I want to suggest to you that you're wrong about, or you're incorrect about the antibiotics.
Antibiyotiklerle ilgili hafızan bence yanlış.
Hafızam yanlış olabilir. Yani şöyle yanlış olabilir. Kendisinin iddiası bu olabilir ama vücudumdaki halen şu parmağım görüyorlardır herhalde. Bir uyuşma hali var. Çünkü damarlarımda sıkıntı olduğu için çok zor damar yolu açtılar benim için ve halen bu parmağım uyuşuk. Çünkü defalarca denediler o antibiyotik yolunu açmak için. Hafızam bu elimdeki ağrıdan kaynaklı çok canlı.
With regards to antibiotics, I could be wrong, but my finger was. I'm showing you my finger. It was numb, and there was blockage in the veins, which was causing issues. So what happened was they opened the vein to open the antibiotic route.
And it should be recorded, the witness was pointing to her hand as she gave that, her left hand as she gave that evidence.
Okay, guys, again, I was wrong when I said I had 20 hours because I assumed that all my videos were 4 hours long. This one is 7 hours long. So I probably have more than 20 hours of this particular trial on my Patreon if you ever wanted to see her. It's free. Like, you don't have to pay. Just because it's Patreon, you can watch videos for free on Patreon. So we're going to stop there. We saw Sue. We saw how great she is. She's greater. I wish I could have pinpointed the parts where she's really good. You kind of saw a little bit there at the end where a witness would say something and she's just like, you're not remembering correctly, or you're wrong. And then she proves it. She absolutely proves it. Like, she's going to pull out the actual prescriptions that she got that day. She's going to pull out exactly what the doctor said. Like, so this lady can remember anything she wants to remember. But she's so good. Feel free to watch as much as you want. And then I'll try to get more of her. Abso-freaking-lutely. Abso-freaking-lutely. I'll try to get some more Australian courts too. But I really appreciate you coming out today. Today is Tuesday. So tomorrow we'll have 2 live streams. One at 4:30 a.m. Eastern Standard Time. The other at 8 o'clock p.m. Eastern Standard Time. I appreciate you guys coming out. Thank you so much. And I shall see you again soon. Behave, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. pumpkin pie. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see